Thank you, Adam.
Well, thank you, and good morning, everybody. I'd like to call this meeting of the California Commission on Disability Access, our quarterly commission hearing. I'd like to call it to order. So let's see. And today is Wednesday, October 27th, 2021. I've lost my agenda. There we go. So Teresa, could you please, is it Teresa that will be reviewing our protocols, our meeting protocols?
Yes, that is correct.
All right, thank you, Teresa.
Good morning. This committee will be on Zoom and via teleconference only. There is no physical location being made available to the public. Per Assembly Bill 361, extending the Bagley-King flexibility through January 31st, 2022, teleconferencing restrictions are waived during the COVID-19 pandemic. Therefore, committee members are not required to list their remote locations, and members of the public may participate either by Zoom or teleconference from any location. This meeting is being captioned and recorded. To assist in this effort, please state your first and last name each time you speak and speak loud and clear. The live captioning link has been included in the chat for your use. For this meeting, CCDA is providing American Sign Language interpretation. From your settings options, you can pin the interpreters to your screen. Public participants can use the raise hand function to alert the committee of when they would like to speak, and we will give an opportunity for public members who have called into the meeting, at which time they can unmute themselves. If you are attending this meeting via teleconference, please press *6 on your keypad to unmute or mute yourself. If you would like to alert the CCDA, press *9 to telephonically raise your hand and staff will call on you. Please remember to mute yourself if you are not speaking in order to reduce noise. If you're having technical issues throughout the meeting and need assistance, please use the chat function to alert CCDA staff or email ccda@dgs.ca.gov.
Thank you, Teresa. So now time for the Pledge of Allegiance. And I'd like to confirm that we have the United States and California state flag behind our Executive Director, Angela Jamont. Is that correct?
That is correct.
Okay, then those that can, let's stand and recite the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation,
under God, indivisible, with liberty and justice for all.
Thank you. Let's see. Okay, agenda item one is roll call. So is that Teresa to lead us in the roll call?
Yes, Chair Commissioner
All right,
Downey.
thank you.
Chair Commissioner Downey.
Present.
Vice Chair Commissioner Weagley. Vice Chair, Commissioner Wheelie. Past immediate chair, Commissioner Lemus.
Present.
Commissioner Allen,
Present.
Commissioner Dillard,
Present.
Commissioner El Hassan, Commissioner El Hassan, Commissioner Holloway, Commissioner Holloway,
Present.
Commissioner Leon Vasquez,
Present.
Commissioner Jackson, Commissioner Jackson,
Present.
Commissioner Parvania,
Present.
Commissioner Nguyen,
Here.
Commissioner Mayenshine, Commissioner Hartado, Commissioner Jones,
Here.
Commissioner Claire,
Present.
Commissioner Safarian. Chair Commissioner Downey, we do have a quorum.
All right, thank you, Teresa.
Thank you.
Commissioner Lillibridge is also here.
At this time, if there are other commissioners or significant persons who would like to identify themselves, would you please do so now?
Charlene Ornelas, a citizen from San Diego.
Okay. Actually, we'll hold off for our public members. I'll call for that in a minute. Okay, there does not appear to be other members to be identified. So at this point, I'd like to see if there are
Commissioner
members.
Chair,
Yes,
I do have a number of names that were notified from the legislative office in
okay.
the chat. So staff, would you read those off, please? The legislative members who have been identified in the chat.
Yes, this is Adam Barsanti. Marisol Ibarra from the Office of Senator Hurtado is present. Shanna Ezel with Assemblymember Manchin's office is present. And Nina Kerschel with Senator Jones's office is present as well.
Okay, thank you. That's
Thank you, Adam.
Yeah. Thank you. This is Commission Chair Chris Downey again. And at this point, I would like to open it up to members of the public that would like to identify themselves.
Good morning. My name is Rita Loof, and I'm a parent of children with special needs. Thank you.
Good morning. This is Maria Arias and Maria Baravino. Members of the public that wish to make comments on item 4 for today. Thank you.
Are there any other members of the public that would like to identify themselves?
Good morning. This is Zinat Hassan from Disability Rights California, member of the public and a member of the CCDA Education and Outreach Committee.
Good morning. My name is Jessica Martinez, and I'm a member of the public. I would also like to make a public comment. Thank you.
Okay, if there are no other members of the public that would like to identify themselves, we'll move on to agenda item number 2, introduction of new commissioners. And for that, we have with us today Commissioner Brian Mayenshing, I hope I pronounced that correctly, and Janet Nugent. So welcome to the commission.
Thank you, Mr. Chair. It's actually Janet Wynn, like
Oh, Wynn,
W-I-N-N.
Okay, sorry
Thank
about
you.
that. Thank you.
No worries, no worries. I'm
Okay.
excited to be here representing the State Assembly, and thank you for the speaker who appointed me. And so I'm looking forward to hearing from you and learning from all of you, actually. Thank you.
Thank you.
And Chair Downey, this is Angela Jamont, and I'd like to share a little bit about our new Assembly members who have joined us in replacement to Assembly members Lackey and Frazier. While we're very grateful and thankful for their service within our board, we do have some extremely great replacements. So with that, I'd like to begin, if you would, with Assemblywoman Janet Nguyen. Thank you so much for physically being with us today. I am greatly honored to share that she was elected to represent the 72nd Assembly District, that is Northern Orange County, on November 3rd, 2020. She is a small business owner, former state senator for the 34th Senate District, and a former Orange County supervisor, and as well as, excuse me, vice president of the government and public affairs for a local chambers of commerce. As a state senator, Assemblywoman Janet Nguyen was named Legislator of the Year by the American Legion and the Association of the United States Army and the Vietnam Veterans of America. She was named Champion of Manufacturing by the California Manufacturers and Technology Association for her work to protect jobs. In addition, she was the first Vietnamese American elected to the state Senate, was the first woman county supervisor, the first Asian American, and the first Vietnamese American to serve on the board of supervisors, as well as the youngest supervisor elected to the Orange County history. During her tenure as a state senator, she was the highest ranking Vietnamese American elected official in California and the highest ranking Vietnamese American woman elected to the office in the United States. We're very proud to have her joining us. And we normally have a pin ceremony, and we will, you should have in your office soon that pin that we hope that you will wear proudly as you serve on this board. We are what we call a very strong, cohesive group with very different opinions, but yet we serve as one. And I thank you for coming in today and being a part of this meeting of the full commission. And again, welcome. And I will quickly, even though we do have a representative, his from Assembly Member Mainshine's office with us today, if I believe Shannon has come in support of his office. We do thank her for attending, but I will also like to share Shannon Ilse, I believe is the appropriate name pronunciation, and she is the legislative director for his office. I will share that he comes from the 77th Assembly District, that's Northern San Diego, and I'm sure someone very in this room closely recognizes that, since 2012. Before joining the Assembly, Commissioner Manchin has served 8 years in the San Diego City Council and has the city's first commissioner on homelessness. He was named the March of Dimes California Legislative Champion for his work to improve maternal mental health. And he also received the Easter Seal of California Assembly Champion Award for his work with the developmental disabled community and the San Diego Humane Society as Hero Compassion Award for championing animal rights. He too has been recognized for his great work. He was named Legislator of the Year by the California Small Business Association for his support of small business. Again, we too welcome his office, his staff, and his participation with the commission. And again, we will be sending out our pin, and we hope that you wear it proudly as you participate in meetings and events and outreach that the commission hosts in the near future. Thank you again for willing to serve and participate on this board.
Thank you, Executive Director and Angela Jamont. And again, welcome to our new commissioners. Welcome. This is Chris Downey, Commission Chair. And now it's time to move on to agenda item number 3, approval of the draft meeting minutes from July 28th, 2021, our last full commission hearing. So assuming all commissioners have had a chance to review the meeting minutes, are there any questions?
I move for approval.
Okay.
Commissioner Holloway seconds.
Okay, thank you. So any further questions, discussion?
This is Director Jamont. I just want to make sure, and for the minute records, if we can identify the names that approved in second.
This is Commissioner Dillard making the motion for approval.
And Commissioner Holloway seconding.
Thank you, Commissioner Dillard and Commissioner Holloway. So all in favor, please say aye.
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 All opposed? Any abstentions? The motion is passed. Thank you. So agenda item number 4, comments from the public, members of the public on items that are not on our agenda. So Teresa, have any, apparently we've already had some members of the public identify their interest to speak at this time, but could you facilitate this section?
My apologies, I was on mute. Yes, I have Miss Rita Loof, her hand is raised.
Good morning, committee members and members of the public. I'm a parent of students with disabilities who has been dealing with the special education system in California for about 20 years. I have witnessed how the special education system has been hijacked by for-profit law firms representing school districts who are acting as a barrier for our children to get an appropriate education. Now, I want to share my experiences as an example of how students with disabilities in California are being denied access to a public education. And I wanted to highlight some of my experiences with the law firm of Fagan, Friedman, and Fullfrost as they engage in hardball tactics against families of children with disabilities. And my family is not the only one that has been victimized by these attorneys. The following is a summary of some of the legal actions that they have taken against our family. They file legal action seeking $10,000 from our family. They prematurely filed legal actions like writ of executions, which is a proceeding used by the Internal Revenue Service to garnish wages and seize property of people who are delinquent in payment. And they have sued our attorney just because our attorney is mounting a defense against the actions by the school district. And all of these actions, and I could go on and on, all of these actions are just because I asked for appropriate reading programs and other special education supports for my child. The FFF standard contract has a clause which allows them to hire private investigators to conduct surveillance on families of children with disabilities. These injustices are happening because our children have no voice, and state agencies such as the Office of Administrative Hearings are quick to turn a blind eye. OAH is a division of the Department of General Services, and this committee is part of DGS. Decisions to litigate against non-disabled employees or non-disabled students have to be approved by local school boards. But students with disabilities are treated like second-class citizens, and they are sued without any board approval. OAH scrutinizes parents and seeks verification from parents to confirm they have authority to represent their own children. But when it comes to verifying that school district attorneys have authority to represent the school district clients, OAH does not bother to check whether or not they're violating the Brown Act and approving by not approving litigation related to special education. So the agency's apathy and double standard has become very obvious to parents, and this needs to change. We're hoping OAH will take a more active role. And I'm sure if districts were asking OAH to correct violations of state law, OAH would have a very different response. So we would like this committee to partner with us to help ensure that district lawyers who are coming before the Office of Administrative Hearings have approval from their boards to do so. Otherwise, they have no standing to appear before OAH. And if OAH does nothing, it will have unclean hands. Please follow us, #more teachers, less lawyers. Thank you for your time.
Thank you.
Yes, Chair Commissioner Downey, we have the next speaker in line is Maria Barabino.
Yes, hi, this is Maria Arias. There's actually two members that wish to make public comment, and we stated that earlier. I'll let Maria Barabino go first. I'll translate unless you have a Spanish translator for there. Okay, I'll let her go.
Muy buenos días, soy María Barabino.
Good morning, this is Maria Barabino.
Una abuela de edad avanzada y con una incapacidad.
I am a grandmother and an elderly person with a handicap.
Yo como miembro del público quiero poder participar en las juntas del board de mi distrito escolar unificado.
I, as a member of the public, wish to participate on the board members of my local school district.
Pero este distrito no me permite participación por teléfono o Zoom.
But my local school district does not allow me to participate either by phone or Zoom.
Yo necesito protegerme del COVID y mantenerme alejada de estar en persona para poder evitarme con contagio del COVID.
I need to protect myself from COVID, and I need to be isolated from people to avoid getting the COVID.
Muchas agencias permiten acceso virtual por teléfono o Zoom. Así que pido a ustedes aboguen por mí, personas como yo, que no podemos estar en persona. Gracias por su tiempo.
So many agencies allow virtual access to meetings, either by phone or by Zoom. So I ask you please to advocate for people like me that are not able to be at these meetings in person. Thank you for your time and thank you for this.
Thank you.
Now, this is Maria Arias. I have a public comment as a member of the public. Good morning, and thank you for the opportunity to provide comment by this means. As my mother just stated, our local unified school district does not allow virtual participation like you have. This is, of course, are hurting our family as we are not able to be in person. And we wish to do participate. So we ask members, your agencies like you to encourage and ask local agencies to allow participation by phone and Zoom. On another subject, I too want to echo the concern of other members that just brought the attention that local school districts are suing parents without board approval. This happened to my family, so I can testify that this is actually true and correct. My son, my 11-year-old son, was sued by the school district on April 3rd, 2020, right during the middle of the pandemic. As everything was closed, they decided to sue us to deny him an assessment and services. When I did a Public Record Act request on this, I learned that the Fontana Unified Board of School members were not aware that the school legal representation had sued us. And I questioned it because I would have said we were going through a great problem at that moment. They could have done other means to assist my child rather than to sue. But what did they decide to do? They decided to put their legal counsel to work. And this is obviously wrong, as it put our family in even additional burden. We had no idea how to handle this as everything was closed. Law firms were closed, offices were closed. We entered into panic as we did not know what to do at that time. So I too would like to request your agency that come up with ideas to ensure that local school districts, in fact, verify that any and all litigation are approved by them and not any other entity like the legal counsel. I believe this is discriminatory because in order for a Black student to be expelled, they need to come into a meeting and have a consensus and vote on it. So I don't understand why would they allow a third person to make a decision to sue the child, especially if this child has a disability. So I strongly ask you, please, to ensure that they do the right thing. The districts cross their T's and dotted their I's and make sure that everything is transparent and legal and it's to the benefit of the student, not just to find or follow legal advice only. And once again, I thank you for this opportunity. Have a wonderful day.
Chair Commissioner Downey, the next person in line to speak is Jessica Martinez.
Thank you. Jessica Martinez.
Yes, good morning. My name is Jessica Martinez, and I live in the Inland Empire area. This morning resonate with me. First, I would like to address the issue of virtual participation. Our local school districts aren't allowing, unfortunately, for a virtual access to meetings, to public meetings, in order to participate by providing public comment. And I have children with disabilities. And so not only access to persons with a disability, but also access by association.
Is it just me having difficult hearing?
Yeah. No, I believe her line dropped. Is that correct, Teresa?
Yes, I don't hear any more communication from Ms. Martinez. I'm not sure if the connection has been disconnected.
Yeah, I heard my system said that her line had dropped. Is there another member of the? Okay. At this point, we've had 4 speakers. I'm sorry that Jessica dropped off. But at this point, we'll move on to agenda item number 5. And that's the Commissioner's Subcommittee reports. And I'd like to ask everyone to hold their comments until all committee reports have been completed. So first up, we have the Legislative Committee, and could Commissioner Paravanya lead us in that report?
Yes, I can. There are three items that I wish to touch upon this morning. One, the committee has developed, and I think I reported this to you before, a document for outreach to the members of legislature to inform offices that we exist and that we have a certain amount of technical information that may assist them in responding to constituents or drafting legislation. And historically, we have done outreach by having meetings at the Capitol, coffee sessions and whatnot. But given the pandemic, things have changed a bit. So we're hoping that this document will help bridge that gap and keep communication going. Also, the second topic I want to touch on is that we provided feedback to the Department of General Services regarding an administrative order impacting how we can communicate with members of the legislature and in what conditions. And we're hoping to obtain clarification on that protocol and open it up a little bit so we're more liberty to do our job with the California State Legislature. Again, we're not in the business of supporting or opposing legislation. We're in the business of providing technical assistance so that things hopefully go well. The last topic I want to touch on briefly is we did have some input through DGS on AB 105, which would have, had it been signed by the governor, would have included people with disabilities in recruitment for boards and commissions. The governor did veto that bill, so that's rather moot at this point. And that is the legislative report for today. Thank you very much.
Thank you, Commissioner Paravanya. Next up is our Education and Outreach Subcommittee report. And for that, we were to have Commissioner El Hassan give the report, the chair of that subcommittee. Unfortunately, she is ill this morning. So Executive Director Jamont, are you able to give us a report?
Yes, I am. I can give a brief overview of the most recent coverage for the E&O Education Outreach Committee. They've been quite busy in the area of public service announcements through radio. We have had an opportunity for Commissioner Chair Downey and Commissioner Subcommittee Chair of the Legislation, Michael Paravanya, to be interviewed by local radio station. And I say local to Sacramento. And they were interviewed, but it has, they have some national outreach in terms of, they have 4 different radio programs that they are broadcasted through. And with that said, they have been able to interview as well as produce a public service announcement informational that the radio station actually is going to sporadically just play for us. And right now on the screen is the public service announcement, and I will read it. And it states, did you know the category of parking has been the #1 alleged physical access violation lawsuit made against businesses? With business operations extending onto parking lots due to COVID-19, it is a growing barrier. The California Commission on Disability Access encourages business owners now more than ever to seek advice from a certified access specialist to not only avoid costly lawsuits, but create an inclusive environment for your business's customer base. Visit www.dgs.ca.gov/CCDA for resources and tools to help your business be accessible for all. This public announcement has been broadcast also through Department of General Services Public Affairs, and will, as I mentioned, continually be produced through the radio. This is additionally, we had an interview during, of course, October as Disability Employment Month. It was also interviewed by our chair, Dr. Sue Hassan, who was interviewed on the local Southern California television station in the morning. And so we've had quite a bit of public opportunities to present CCDA and the work that we're doing. So that is, in terms of E&O's announcements, a report back from her committee.
Thank you, Executive Director Jamaat. Thank you for pitch hitting on that report. Next up, we have Commissioner Holloway for the checklist subcommittee report.
Okay, good morning, everybody. I want to say that the checklist committee has been primarily focused this year on our accessible parking campaign. And earlier in the year, we established a working group to develop the toolkit, and we set our goals and our times for that. In March and June, we determined who our target audience is and our information needs. And then between July and October, staff sent out 20,000 questionnaires to ADA coordinators, local government, business owners and operators, and building construction specialists, asking how they like to receive the kinds of information that we need. And what was interesting, there was a whole series of descriptions of how people could receive different kinds of information relative to parking design and construction, parking lot design and construction. And although we gave them several choices, more than half of them basically said they like to receive the information in all the manners or all the choices that we gave before them. And the survey results and the questions are in today's board materials, and you can see them on the screen right now. And so it gives you a flavor for the types of questions, the types of information, and how, the choices they could have to receive that information. And then lastly, I just want to mention that for the rest of the year and into next year, we will continue marketing and distribution of our open air dining curbside pickup access program. Any questions?
Well, thank you, Commissioner Holloway. Yeah, so at this time, I would like to open it up to questions from members of the commission for any questions or discussion on these subcommittee reports.
Chair Commissioner Wheatley, Chair Commissioner Downey, I just wanted to acknowledge Commissioner Wheatley has now joined the meeting. Okay. And our first individual that would like to speak is Rita Loof for item 5.
Thank you.
I'm sorry, participant Rita Loof for item 5.
Did you want me to go ahead now, or did you want to take comments from the committee members first?
Was that Angela Jamaat in the background? But I think I'd like to hear comments or questions from the commissioners first.
This is about.
So any questions or comments from members of the commission? Hearing none, then we'll move on to comments from and questions from members of the public. Thank you.
I'll go ahead. My name is Rita Loof. As I mentioned, I'm a parent of students with disabilities, and I realize that the commission doesn't necessarily take support on bills and formal positions, but as was mentioned earlier, you do take technical, or you recommend and provide technical assistance. So I would encourage the commission to consider the issues of access to special education and the vexatious litigation that school districts are engaging in with public dollars, and how we can work together with the Office of Administrative Hearings to protect the rights of these students. So thank you so much.
Thank you.
Chair, Commissioner Downey, we have another individual, Maria Barabino. She is, I guess, going to be translating for Maria Arias for a comment that she has.
Thank you.
Actually, correction, this is actually Maria Arias, and I will be providing the comment on this issue.
My apologies.
That's okay. Thank you. Once again, this is Maria Arias. I am the member of the public, but I'm also a parent of 3 children with special needs. All of them unique, all of them my beautiful children, but they all require attention and services through this school district. For 17 years, I have struggled with the school district. I believe, just like the public member earlier mentioned, there is no access to our children's education. And let me correct that. It's a constant battle that a parent has to do for their children to obtain the appropriate education. With my oldest daughter, who has Down syndrome and autism, I've been battling since day one, because the district believes that all where they require were to give her a place to go, a place to sit down, and do the minimum or nothing in regards to her education. Luckily, I got smart, educated myself, and I was able to be trained by myself and other local agencies like Disability Rights and other programs. Luckily, I was able to learn about the law and education and codes. And I was able to learn that by advocating for my child, I finally was able to access education for her. If I didn't have done this, I would allow the school district to confine her in a small classroom they call SDC, special day class, and just have her there sing and write up to 5 letters, 5 words. So
if I could, I'd like to interrupt and ask you to really specifically address the agenda items that we're speaking to. We could better focus towards that.
Yes, where I'm heading to is the fact that I believe that education, special education to be exact, is not providing access to special needs children in general. There is a culture that does not allow districts to see the potential of all the children. And I believe that denies them access to education. So I believe if there was more training and more collaborative working between districts and parents, that we will be able to provide access to children with special needs to education. That's where I'm heading to. Thank you.
Are there any other members of the public that would like to speak specifically to this agenda item?
Chair,
Teresa?
Commissioner Downey,
Yes.
I don't see any hands raised.
All right, thank you, Teresa. So next up is agenda item 6, the executive director report. So Executive Director Jamat, could you leave us in the review, your report on the CCDA, let's see, administrative and operational summaries. Thank you.
Yes. So I'd like to begin first with the discussion on our proposed calendar for the year 2022. This was presented to the executive committee at your meeting, and the calendar is reflective of the full commission meeting, executive committee meeting, legislative committee meeting, checklist committee meetings, and education and outreach. I will begin by sharing some of the highlighted changes that we're looking at 2022 and comparative to 2021. Beginning with the fact that the times, we have now moved all the meetings recommended to be 1:30 to 3 p.m. for the executive and legislative checklist and its education outreach. The full commission meeting will remain the same time. So that's the first thing. The second highlight of this calendar is the proposal of acknowledging that the Bagley-King meeting provisions are set to expire, I should say, the meeting provisions that was created to include the fact that we can extend to January 31st, 2022, the provisions that members of committees do not have to be in public locations. That ends the end of January. So with that in mind, we're looking to identify in our full commission meetings, full commission and the executive committee meeting, that it will stay as we have today, that it is all members can be wherever they are and do not have to publicly identify where they're calling from or identify where they're at. With that understanding, we recognize that potentially the bill would not continue this extension, or no other bill will come out in to remove the extension or extend the extension, but we went on the thought that it will revert back to as it was before. So with that in mind, along with that we are still in a pandemic, we wanted to find ways to best address the opportunities for our board members to participate together, as well as potential continue virtual meetings of convenience. But with that convenience, it would be in any location that a member of a committee would have to be in a publicly noted location. So with that said, to all of you, for those who are not familiar with the Bagley-King concept, and you will be in a little while because we have presenters who will be speaking on this very topic thoroughly, so I won't go highlight it for you. I will just share that if you are in a location right now that is not something that you would want to be publicly accessed by the public to come in and join you in that facility, you would have to then come to the meeting location that the staff has created. So typically we always have in our conference room available space for those to come in, and it is a spacing that we will have it that can continue to fit into the regulations of spacing 6 feet apart and so forth. So with that said, we do have the recommendation that the calendar of April the 20th is a full commission meeting, July this 27th, and then October the 26th. Now, I will share with you that we have identified the full commission as a hybrid, so full commission in January the 26th. And I should have put my glasses on because also I can't read. 26th as the same. And then April the 20th, we identified that possibly that could be a hybrid. And then the rest of them potentially hybrid in some locations. So those are the dates and the possibilities of hybrid for the full commission meetings throughout the year. The executive meetings we identified as potentially to be in location with particular projects that we have the chairs to participate in when they come to Sacramento. Noted here, we have them all in Sacramento, and we are looking at potentially, as Commissioner Paravaglia mentioned, more active responses to working with legislators in their offices and various communications with our actual legislative members on our board. That's our hope and desire, to be extremely or strengthen our relationships with our legislative members. I'm so appreciative that the ones who are on the call. Commissioner Jones has been with this time and time again, and all of them have actively participated. And we'd like to do even better work in 2022. The rest of the meetings, we typically always have the subcommittee meetings as a teleconference. So we have, we're working on making that more teleconference, Zoom. We are in the process of researching to develop a better audio system, because right now we have a conference phone with 2 speakers, and we know the biggest thing is we want people to feel like they really can participate clearly, in a sense that they are in the room, can be heard, and be responsive to those who are speaking. So again, the calendar has been presented. We are not necessarily voting on the calendar at this meeting. We are presenting it. We hope that all committee members take a look at these dates. If you have some hard, fast dates that are on your calendar that is in conflict, we ask that you send it as quick as possible to the staff, and we will respond to the chairs, because the chairs, more importantly, have to make sure they're there. So we are asking that as best we can, that you, as members of those committees, let us know, and we can possibly work through those dates before the calendar is finalized. This is considered a draft. Any questions or comments on this particular one? I would welcome it now.
This is Commission Chair Chris Downey. The one clarification I'd like to add is that when mentioning publicly noticed location for commissioners to connect in remotely, that space is required to be fully accessible to members of the public. So it's important that you both identify to the staff in time that it can be publicly noticed, and that space be fully accessible.
Thank you, Chair Downey. That is clearly something we do, but I did not vocalize it. But so I appreciate you reminding the public that we are extremely conscious of accessible locations. And so that is extremely important that anyone who opens up their office or space, that they look into those particulars as well. My next, if there's no more comment on that, I will move to the next administrative discussion point, and it is in regards to public comments within our meetings. Government Code Section 1125.7 provides the state body may adopt a reasonable regulations to ensure that the extent of subdivision A is carried out, including not limited to regulations limiting the total amount of time allocated for public comments on particular issues and for each individual speaker. We have reviewed a number of commissions and boards, as well as our own history of operation. And we wanted to make sure that our chairs, and this year has been a number of things we're working on, trying to make sure our chairs are equipped as full as possible in how they run their meetings, and consistently for all chairs to run their meeting throughout the year. And this particular one, we wanted to make sure was identified, and that is the ability and the means of which they actively work with the public. We, with that said, excuse me, the staff has created a recommended policy that the executive committee accepted, and now we're introducing it to all of the members of the commission to understand this is a policy that we are identifying to move forward going in 2022. and it reads as follow as a recommendation. We have 3 recommended highlights. 1, the commission may not discuss or act on any matter raised during the public comment section, except to decide whether to place the matter on the agenda of future meetings. B, time limitation to discuss and comment within an agenda will be determined by the board chair and/or subcommittee chairs. However, the general standard for all chairs to follow is 2 minutes per person during the non-agenda item up to 5 people, and 2 minutes per person up to 3 people per agenda topic. And then lastly, recommended by the staff is C, a person who needs a disability-related accommodation and/or modification because of language translation will be provided extended time to present during public comments. This is our recommendation for going forward. We will have this also amended into our agenda documents. So those who are participating will also understand this is how CCDA will be operating as well. Are there any questions or comments? So next, I did want to quickly just move into some structural changes we made to our website. While we don't have it necessarily on our screen, because we want you to go to our website to look at it and to review it. So we made some structural changes to the tabs. One, we created a Business Connect tab. With that, it has all our resources for business minded folks. And we also have created a tab on their website that directs the legal community of how to access the portal, of which they submit case filings and pre-litigation letters. So we ask that those who have not been on our website of late, please join in to check it out, because it indeed has a number of identified updates, as well as the interview that I mentioned in our presentation from the A&O committee. The interview is literally on the website, and you can hear the comments by our commissioners. The last thing in terms of presentation as an executive report is regarding our outreach and partnerships. We have, as mentioned from Commissioner Holloway, the extended outreach to our document of open air dining and curbside pickup disability access consideration. We have been in relationships with our Chico Chambers of Commerce. We have also been in a number of with other cities, Milpitas and San Jose. We've met with them, and so we've been outreaching to develop more cohesive projects together. And with that said, our project is being underway in the area of the webinars creation with the California Governor's Office of Economic Development, that is known as GOBEZ. We're working with them and the Division of State Architect, that we'll be putting on a series of webinars in the upcoming time schedule. And we will be actually launching the first webinar, introductory webinar, tomorrow. And so that time is tomorrow, Thursday, from 3 to 4. It is a free webinar. So there's a link on our website. If you go to our website, or as well as the Division of State Architect, they have it on their website. It was publicized through GoBiz, and they have a membership of, I think, a list of 75,000 folks that it was marketed to. So we're really excited about that opportunity of partnering with them. I have just and to close out in terms of working with partners, I was actually participated on the California Lawyers Association webinar last month, and I partnered with a law firm as well as a expert in web access. And that was kind of the little bit of discussion for them. We took the time to emphasize from CCDA standpoint the responsibility of attorneys to submit their cases. So we took that opportunity to share about who CCDA is from their perspective and needs to know. So been busy in these last part of this quarter with partners and outreach. And that concludes my report today. Any questions or comments?
Thank you, Executive Director Jamont. Any questions or comments from members of the commission? Hearing none, Teresa, are there any members of the public that would not like to speak to this agenda item? Teresa, if you're speaking, you're on mute.
My apologies, Chair Commissioner Downey. Yes, we do have someone, Miss Rita Loof, that had mentioned that she would like to speak.
Yes, thank you. And I noted my comments in the chat box, but I'm not understanding how this new policy would play out and how the speakers would be selected, because if there's more than 5 or 3, you know, how are the speakers going to be selected? Arguably, one person will have a chance to speak and then other people will not. So it does have the potential for making it a problematic process. And not to mention, it'll just send out the message to the public that the commission does not welcome public comments freely and that comments are being restricted. So that's all. Thank you so much.
Thank you. Are there any other members of the public that would like to address that agenda item? Okay, hearing none, we'll move on to agenda item number 7, the financial summary of the CCDA fourth quarter financials. And for that, I believe Phil McFall is to address that.
Thank you, Commissioner. Good morning, everybody. I'm here to talk about our fiscal year 2020-2021 fourth quarter budget highlights. First, let's talk about our expenditure authority. Can everybody see the graphic? Hopefully. There it is. All right. Let's talk about our expenditure authority. We have 7 authorized positions. We currently have 5 positions filled. We are looking to fill the other 2. Our personnel services and wages benefits. So basically we have $750,000 for personnel services that we had allotted to us for the year of 2020-2021. Our operating expense budget was $771,000. The total authorized budget was $1.521 million that we had available to us. So let's talk about I'm sorry. Okay, I thought somebody was saying something. Let's talk about personal services. The budget of personal expenditures, like I said, was $750,000. Our reported expenditures through the fourth quarter of the 2020-2021 fiscal year were $514,745. That equals 69% usage of the CCDA expenditures for personal services. So we were projected to close at 70%. So we were like, it looks pretty spot on for that category. So our operations manager, which is myself, was hired during the third quarter of the 2021 fiscal year. And our legislative administrative analyst that we had hoped to hire prior to the end of the fiscal year remained vacant. So that is something that we're actively working on currently. And now let's talk about our operating expenses. Our authorized authorized budget was $771,000 for that, and through the fourth quarter we used $598,377, and that represents 78% usage of our expenditures. And we were projected. I'm sorry, we closed at 87%. I'm sorry, we closed at 78% of our operating budget. I'm sorry. During the fourth quarter, we hired 2 consultants, and we had numerous service contracts also that were closed in the fourth quarter. So we had a lot of activity in the fourth quarter of the 2020-2021 fiscal year, and just to let you know that we're looking to hire 2 more positions in the office, and that's pretty much all I have to share today. What questions do you have for me?
Thank you, Staff Member Bill McFall. Are there any members of the commission that would like to ask any questions or make any comments?
Yeah, Commissioner Downey, I'm sorry, I forgot the last part. I was looking high, and I forgot about the revenue. We did have our revenue for 2020-2021 is $46,912. In the fourth quarter, our revenue was $9,054. So we did generate a little bit of revenue for 2020-2021 year.
Thank you for that additional comment. So any further comments? Any comments from commissioners? Comments or questions on this agenda item? Hearing none. Teresa, are there any members of the public that would like to address this item?
Chair, Commissioner Downey, I do not see any hands raised or indications in the chat for members of the public that would like to speak.
All right, thank you. So agenda item number 8, legislative bill tracking. There are 6 bills to present. And unfortunately, the DGS legislative consultant, Karina Roy, is not available today. So I believe Executive Director Jamont, you'll be giving us that report. And please hold all questions to the end.
So I will begin with AB 29 by Member Cooper. This particular bill will not be moving forward this year, is held in suspense file. This bill would have expanded notice requirements under the Bangor-Keene Open Meeting Act. This bill would have required posting all writings, materials provided by commissions staff to commissioner members in relation to an item on a meeting agenda to be posted to the website as soon as they have disseminated or no less than 72 hours prior to the meeting, whichever is earlier. A commission may discuss these writings, materials, or take action on them only if the meeting, only if it complies to this particular bill. And again, this is on suspense. AB 105, vetoed by the governor, as mentioned by Commissioner Paravanya. This bill would have remained, would have been requiring that all state boards and commissions consistent of 1 or more volunteer member or commissioner to have 1 volunteer member or commissioner from an underrepresented community. This provision shall only appear as vacancies of state boards and commissions occurred. As mentioned, it was vetoed. I will read the letter the governor wrote regarding this particular bill and why he vetoed it. This bill would modify several processes to civil service jobs, announcement, exams, classification, and hiring practices. Additionally, it would require certain boards and commissions to include appointed representative of underrepresented groups and institution new data collection requirements. I believe that California has a responsibility to recruit and retain a workforce that is reflective of California's diversity and treatment of all of our employees with respect, dignity, and quality. My administration remains committed to furthering that cause, and that's why we have established the California Leads as an employer initiative. The goal of this initiative is to implement policies that promote a diverse and inclusive workforce reflective of California, ensure a respective workplace free of harassment, and address gender and racial pay gaps in state workforce. Additionally, we established a chief equity officer at the Government Operations Agency this year, who will focus on diversifying state hiring, recruitment, retention, and training. While the goal of AB 105 is laudable, and elements of the bill conflicts with existing constitutional requirements, labor agreements, and current data collection efforts. Therefore, it may have unintended consequences that warrants further consideration. Furthermore, AB 105 would cost $10 million. These one-time and significant ongoing costs should be considered through the annual state budget process. I would encourage the author to collaborate with administration to address these concerns and look forward to continued partnership as we continue to work to build a more inclusive state government. AB 361 Rodriguez, signed by the governor on September 16th, went into immediate effect as an urgency status. This extends certain provisions of the governor's executive order 2920, which suspended specific public meeting requirements for the state bodies under the Burger King Open Meeting Act. This particular bill, as we read earlier, will suspended under current, it will go back into effect January 1st, 2022. So it reverts back if there's no other bill that comes up within the change of this extension. More discussion will occur during our our training and shortly. I'll move on to the next bill of AB 580 Rodriguez, signed by the governor October the 9th, 2021. This bill requires the Director of Office of Emergency Services to appoint representatives of the Access and Functional Needs community to serve on committees that work to create, maintain a standardized emergency management system. At least a majority of the appointees shall be represented from the blind, visually impaired community, sensory and cognitive disability community, and the physical disability community. Furthermore, it requests by the county, the bill requires OES to review the county's emergency plans to determine if plans are consistent with best practices and provide assistance to local jurisdictions to help them meet access and functional needs. Signed by the governor July 9th, 2021, AB 1291 by member Frazier. This bill requires a state body that limits the time to public comment, provide twice the allotment time to members of the public who utilize translation services to address the body, and it will go into effect January 2022. AB 1429 by member Holden. This bill was held in suspense in the Senate appropriation, and it died. The bill is dead as of 2021. So this was a second year. And this bill would have required an agency record management coordinator to provide record management training to all agency personnel who prepares, owns, use, or retain public records on behalf of the agency, and to ensure that agency personnel completes their record management training within 60 days of employment, includes 30 minutes of refresher records of management training linear thereafter. And I believe I reviewed all bills that we were identified in this fiscal year.
Thank you, Executive Director Dramont. At this time, are there any comments or questions from members of the commission? Hearing none, Teresa, are there any members of the public that would like to address this agenda item?
Chair Commissioner Downey, I do not see any members members of the public with their hands raised or anything in the chat indicating they would like to speak.
Okay, thank you, Teresa. So now it's time for agenda item 9, Badly Keen training. And for that, we've got California Department of Justice attorneys, deputy attorney generals, Ted Prim and Thomas Bruder.
Can you hear me?
Yes, we can.
Okay.
Thank you.
All right. And Thomas, are you there?
Yeah, this is Thomas. Let me do a mic check as well. Can you hear me?
Yes, we can. Thank you.
Okay, great.
Okay, you ready for us to begin?
The floor is yours.
Okay, thank you very much. Well, welcome to our tour of the Bagley-Keene Open Meeting Act. My name's Ted Prim, and we'll be presenting this with my colleague Thomas Bruder. We're both Deputy Attorneys General with the Government Law Section, which is one of the many sections in the Attorney General's office. Thomas got his experience with open meeting laws primarily through doing different kinds of finance and bond work. So he's a bond attorney and a finance guy. I, on the other hand, have worked with different kinds of transparency laws throughout my career. So things like conflicts of interest and the Public Records Act. And then, of course, the Bagley-Keene, which is the state open meeting law, and the Brown Act, which is the local open meeting law. So with that as background, let's dive right in and talk about the Bagley-Keene. So the first thing that I usually hear from people about the Bagley-Keene is how frustrated they are with it and how it deprives people of their natural forms of communication. And of course, they're right. It is frustrating sometimes, and it does deprive you of your normal means of communications. And compliance with the Bagley-Keene Act is not intuitive. But what we want to do here today is to talk about both the framework of the Act and where it came from, and then specifics of the Act's requirements. And in these ways, we hope that you'll understand why these provisions exist, and that it will become easier to accept the frustration and some of the steps you have to go through with the Bagley-Keene once you understand why they're there. So by the end of this, we don't think you'll necessarily be ready to cuddle up with the Bagley-Keene, but we hope that through understanding, acceptance will occur. So one of the first aspects of frustration that people feel is they say, well, it's so inefficient, and we wish we had something more efficient. But when the legislature created boards and commissions in particular, and the Bagley-Keene, efficiency was not the number one goal that they were looking at. If you want efficient government, then you create a departmental pyramid structure with a decision maker at the top and a support staff at the bottom, and you allow that person to streamline the process to get to decisions as quickly and efficiently as possible. But when you set up a commission, you're looking at something different. You're looking at a consensus building process by which you create bodies that have members on them with different backgrounds and different viewpoints and different experiences. And then through the process of debate and deliberation and give and take, you arrive at a consensus decision. And that automatically takes a lot more time just because of the way the decision-making structure is set up. Now, when the legislature created the Bagley-Keene Act, they wanted to further this consensus building process by including the public. And so what the Bagley-Keene does is it says when the body is arriving at its consensus decision, we want to have a seat at the table for the public. So open and public meetings, public notices of when and where meetings are going to be held and what the meetings are going to involve, allowance for public testimony, and access to public records. These are all the ways in which the consensus-making process by different boards and commissions are made transparent and accessible to members of the public. Whenever we have a closed session, and we'll talk about this a lot more in a little bit, whenever you have a serial meeting, those two situations deprive the public of their seat at the table and undermine the goal of public participation. So in the case of closed sessions, we want to restrict them as much as possible. And of course, serial meetings are illegal. So that's the framework we're operating from. And our hope is that by understanding the premise on which we have constructed the Bagley-Keene, that it will make it easier to deal with these situations. So what I didn't explain at the beginning is we're providing this training in segments, and we've now come to the end of the first segment. And each time we get to the end of a segment, we're going to stop and open it up for discussion. So you don't have to remember your questions for very long. So before we go on to the question of what is a state body that's covered by the Bagley-Keene, is there any discussion that we want to have about the creation of boards and commissions and their consensus building features and the Bagley-Keene and how it seeks to involve the public? Okay, so if there are no questions, I'm going to pass this on to Thomas now.
Okay, thank you very much, Ted. The Bagley-Keene Act is California's open meeting law that applies to multi-member state bodies. So state bodies that have 2 or more members. And it's important to remember that it applies not just to incumbent members of a state body, but also to newly appointed or elected members, even if they have not yet assumed office. So during the course of our training, this should be kept in mind. What is a multi-member state body subject to Bagley-Keene? This can be created in 5 ways. A state body can be created by statute, which is in fact how the commission was created. A state body can be created by an executive order of the governor, which is a little bit rarer. The third type is a state body can be created by a delegation of authority from another state body subject to Bagley-Keene. And the most typical example of this would be an executive committee. So if the commission has an executive committee and it has delegated authority to the executive committee, then Bagley-Keene also requires open meetings of the executive committee in addition to the full commission. The fourth type of state body is if the commission is providing funding to another public or private entity, like a nonprofit, for example, and if a commissioner is serving in an official capacity on that body, then Bagley-Keene would apply to the board meetings of that nonprofit as well. And then the fifth category is for advisory bodies, but these are a little different from the other 4. Bagley-Keene only requires open meetings of an advisory body if it has 3 or more members, rather than 2 or more members. But the flip side is that an advisory body, of course, can only make recommendations to the parent body. It has no decision-making authority. An advisory body can also include staff and members of the public, in addition to commissioners. And there must be some type of formal action on the part of the commission in creating the advisory body. Although courts in California take a rather expansive view of what counts as formal action. So if a member of the commission simply directs staff to create an advisory body, for example, even if the composition of the advisory body is up to staff, that's likely going to be sufficient formal action for Bagley-Keene to apply. And then finally, with advisory bodies, there's this concept of an impromptu advisory body, and this is very important. If 3 or more commissioners are meeting regularly outside of a public meeting to discuss the commission's business, then they may inadvertently create an impromptu advisory body that is subject to the act and requires open meetings. So if let's say 3 commissioners meet for coffee one morning and they're just discussing personal matters or making small talk, that's not an issue. But if they start discussing commission business and this becomes a regular thing, like every Tuesday morning, commissioners are meeting to talk about commission business, then those meetings actually will have to be open to the public. And so for that reason, we advise the commission to follow what we call the rule of two, which is that no more than 2 members of the commission should discuss commission business outside of a public meeting at any time. Because if a third commissioner joins those discussions, it's getting close to looking like an impromptu advisory body. So those are the 5 kinds of state bodies that are subject to the act. Are there any questions about the 5 categories?
Let me add a couple of comments to what Thomas has said. In the case of the impromptu meetings, not every gathering of 3 members at the coffee shop to talk business before a meeting would trigger the impromptu thing. But you run the risk of it being an impromptu advisory committee meeting at some point if it becomes a regularized thing, or if, for example, the commission as a whole knows that this group of people meet regularly and they depend on them in some fashion to screen things or discuss things ahead of time. So the occasional meeting of people on an impromptu basis, which is not at all arranged or organized by the body itself, would be okay. But if it becomes regularized, that's when we're warning you that you're walking into potentially dangerous territory. The other thing that Thomas said is that for advisory committees, those can include staff. So if you appoint staff to an advisory committee, then they're going to be members of the advisory committee, and that absolutely is going to count. But it doesn't mean that you can't appoint an advisory committee and then have staff support that advisory committee. So if staff is only in a supporting role as staff and they haven't been appointed as members, then that would be fine and they would not be included as members of the committee. So if you have a 2-person advisory committee and then staff is there in support of it, that doesn't make staff part of the advisory committee. But if you say that you want to create a 2-person advisory committee and then you want to also appoint your executive director to the committee, that's going to be a 3-person advisory committee. So that's an attempted clarification, but I probably just made it worse.
Thank you. This is Commission Chair Downey. That was very helpful. Thank you.
Okay, good. All right, shall we go on to the next step?
Yes, please.
Yeah, I
Okay.
think turn it back over to you, Ted.
Okay. So I'm going to talk about what is a meeting. And for the most part, it's pretty obvious. So the typical kind of meeting is the one we have here today, where we have a gathering of a majority of the members of the body at a meeting, and where we've got an agenda and notice and everything is cool. And that's for the most part what we're dealing with here, is where body comes together and to discuss and deliberate and or take action on issues under its jurisdiction. Now, in many cases, just the mere receipt of information can also be a meeting. So if you're having a presentation and none of your members are asking questions, they're just listening, that's still a meeting. You're still dealing with issues under your jurisdiction. And by agreeing not to talk, that doesn't somehow take it out of the realm of being a meeting. We have 5 different types of meetings. They're mostly controlled by their notice provision. So we have the regular meeting, which is I think what we're having here today. It's noticed 10 days in advance. There are provisions for special meetings, but those take 2 things. 1, it's restricted subject matter. 2, it can be done in 48-hour notice. So it's designed to deal with situations which are time sensitive, but it is limited by statute to certain subjects, and then the body has to make certain findings of necessity in order to engage in that meeting. Their emergency meetings, they have 1 hour notice limitations, but they're very restricted. They can only deal with certain kinds of disasters and work stoppages. So the normal thing that most bodies would consider an emergency for them are not considered to be an emergency by the statute. And then finally, we have teleconference meetings. And we used to only have one kind of teleconference meeting, and then we had the statute amended, we have 2, and now we've got 3. So Thomas will discuss those in more detail in a little bit, the different ways in which you can have a meeting by having your commissioners in remote locations. So now to the biggie, and that is that the Bagley-Keene Act also covers, or actually what it does is prohibit, serial meetings. And a serial meeting is where you have a series of communications, when taken together, involve a majority of the body on issues that are under the body's jurisdiction. So some examples, let's take a 5-member body. If member A discusses, and let's just assume to make it easy that we're talking about agenda items on the next agenda, and member A talks to member B, and member B talks to member C about this particular agenda item. At that point, we have a majority of the 5-member body that are engaged in discussions on an agenda item. That's a serial meeting. And because it hasn't been noticed and the public's not present, we don't have all the trappings of a public meeting, it's one that's in violation of the law. The same with what we would call a hub and spoke meeting. A talks to B, A talks to C. We have 3 out of the 5 get involved. And it can also happen through intermediaries. So if the staff members of A, B, and C get together and talk about the agenda item and what the members might do, that also would be a serial meeting. So the reason we don't want to have serial meetings is because one of our goals is to make sure we have public participation. And when we have a serial meeting, by necessity, we don't have any public participation, and therefore we run the risk of going to the meeting with people already having received information and made up their minds. Serial meetings can occur in a lot of different ways. They can be face-to-face. They can be through email. They can be the way that they used to do it, by telephone. That can still happen. Text messaging, and then all kinds of other technological things, which frankly, I'm not up to speed on. But any way in which you can participate in that consensus building process, and where you're starting discussions and deliberations towards making a decision, all of those things would count as serial meetings. One issue that came up along the way was what about the discussions between the staff, and I'll just use as a substitute for the word staff, the executive director, and his or her relationship with individual members of the board. So we know that one of the things the executive director could do would be to be an intermediary in a serial meeting, and that would be improper. But what the legislature did do is it set up some limitations in order to allow executive directors to speak with their boards. And the purpose of it is to prepare the board for the meeting and make sure that the board feels like it's well-informed and well-armed to go into the meeting. So the executive director can have individual conversations with board members, but statute specifies they need to be one at a time. So the executive director can meet with member A, then they can meet with member B, they can meet with member C. They can't meet with them together under this provision. But the other rule is they also can't share. So when she meets with member A and then meets with B, she can't say, oh, by the way, I had a conversation with A the other day and here's what he thinks. They're siloed. So the purpose is to make sure that the executive director is not conducting a serial meeting, but it's to make sure that member A feels like he or she has the information that they need going into the meeting. I see we got item number 3 here. I don't understand the staff memo on this particular point. Can you clarify that for me? Or I'd like more information on such and such. Could you get that for the meeting so that we can all understand this better? You can have those kind of communications, and that's what the purpose of it is, specifically not to be a subterfuge for a serial meeting, but it is designed to make sure that people are able to be prepared when they go into a board meeting. So this issue of meetings and keeping them open is really, at the core of the process. That's where the rubber meets the road. And if you think about it in terms of things that are going on in California today, if there were a fire in your neighborhood, or if you're having flooding issues, or if there's a chemical spill or a railroad derailment or whatever, and you go to the meeting, you want that meeting to provide you with information about what's going on, and you want to see the decision-making process occur. You don't want people coming into that meeting with having talked to interested parties of their choosing and having a decision in their pocket in which they then just treat you as a formalistic aspect of getting through the meeting, but they don't really have to address your concerns or share information with you. So that's the purpose of all this, is to try to make sure that the meetings are meaningful and that the decision-making occurs in public. Okay, so that's the conclusion of what's a meeting. Any part of that, particularly serial meetings, that you want to talk about?
Attorney Prim, this is Director Jamat, and I wanted to comment on the communications from the director. What I made as a practice for our office is that we would send maybe a communication to all board members, but request only that they do not reply in CC to everyone. So they will only reply to me directly or directly to the staff who's sending it out, but not to make it where everyone sees the communications back and forth.
That's a good practice to make sure that people don't fall into the habit of doing that CC and sharing. So that's a good step. Go ahead.
Yeah, so I just wanted to identify that in terms of that is a way of getting around being the hub, because that has been historically one of the challenges within emailing and trying to make sure everyone has the same information. But at the same time, I've had to try to make sure no one is CCing or back to the distro list.
Right. And most of the time, that communication is also probably going to be a public record that people could request if they wanted. So when you make a communication to a majority of the board, that is usually a public record.
Thank you. I do have one question. I think I heard you say about emergency meetings in terms of the time of which limitations of creating a called special meeting. Did you say something to that or repeat it if you did say it, if you could repeat it? I think I understand, but I just wanted to clarify
Okay.
on that topic.
Okay. So special meetings are 48-hour notice. But the subject matter of a special meeting is very limited. And I'm not looking at the statute right now, so I'm not 100% sure, but basically it's litigation. I believe there's a piece in there on legislation, personnel discipline, and some things like that. So there, you have to do several things if you want to have a special meeting, which is you have to check and see if you're on the limited subject matter. If what you want to have your special meeting about is not in that list, then you can't have it. You're going to have to do a 10-day meeting. If it's on that list, then you're okay to go on the subject matter. So then you have to do the 48-hour notice. And there are some special requirements for who that notice has to go to. And then when you get to the meeting, before you can actually have the meeting, your board is going to have to make a finding. There's two different findings that are listed in the statute that you have to make a finding on one of those in order for your meeting to proceed. Emergency meetings are 1 hour notice, and they are to deal with things like natural disasters and strikes, basically. And so it's not on most things that would be emergencies to most bodies. It's on just a couple of things that are truly emergency issues for the government. So it allows them to meet on short notice and only in public. No closed sessions in an emergency meeting. So if you want something more on that, I can send you the statutory provisions. We can send you a little summary of how those work. It's like I say, they're very limited and hardly ever used, the emergency meeting provisions.
Thank you.
I did want to say, let's see, I'm trying to think what it was. I guess it's actually subsequently. But now that I've started blathering on, let me finish it. I came in partway through your items that preceded this presentation, and I heard something, but I didn't understand the full context of it, about public testimony and allowing testimony from only a certain number of people or whatever. Could we perhaps follow up on that after this meeting to make sure that that's not problematic?
Absolutely.
Okay. All right. Anything else on meetings? And you have a chance again at the end of the presentation if you want to come back to anything. All right, Thomas, you're up.
Sure. So certain kinds of gatherings of the commissioners are not subject to the open meeting requirements. And the key is that the commissioners are not discussing commission business among themselves at these gatherings. So the first is that a commissioner may meet with any non-member of the commission, such as staff or the public, at any time. Although remember that the non-member or non-members may not pass along communications of other commissioners, or that would become a prohibited serial meeting. So the second kind of gathering is conferences that are open to the public on a topic of general interest to the public or a wide array of governmental officials. Again, as long as the commissioners are not discussing commission business at the conference, then that is not does not have to follow the commission's open meeting requirements. But a small workshop on a narrow number of topics with just a few officials likely is not going to fit within the conference exception. So it really does have to be something that's of general interest to the public. And as I said, a wide array of governmental officials. So then the third kind of meeting that doesn't have to follow the open meeting requirements is open meetings of other public bodies on a topic of state concern. Again, as long as the commissioners are not discussing commission business among themselves while attending a meeting of another body. The fourth category is meetings of the commission's standing committees, if they are open and noticed meetings. A standing committee is a committee that meets regularly. It's not like an ad hoc committee that has just a temporary purpose. And the additional rule is that the members who attend the meeting of the standing committee who are not on the committee may only attend as observers and may not participate. The fifth category is for just typical social gatherings. So you don't forfeit a social life by becoming a member of the commission. So as long as, again, commission business is not discussed at a social gathering, then that does not have to follow the open meeting requirements. So if the commissioners meet to have lunch and you're just making small talk or discussing personal matters, that's not an issue, but a working lunch would likely not be appropriate, since the purpose of a working lunch is to discuss commission business. And then finally, the sixth category is one-way confidential legal advice of legal counsel to the commission. So legal counsel may circulate a memorandum to the commissioners without having to do so in an open meeting. But one rule for that is that the members may not discuss the legal advice among themselves outside of a public meeting, or perhaps in a closed session exception if one of the exceptions is applicable. So any questions about the 6 categories or gatherings that are not subject to the open meeting requirements?
Yeah, this is Commissioner Paravani. I have a question. If we have a forum, a public forum, and say there are 80 or 100 people there from the public, and there may be 5 or 6 commissioners there, and a group of 4 or 5 people that are panelists to discuss an item that the commission is looking at and considering, how do we deal with that?
And are any of the commissioners panelists or just attending in the audience?
Mostly just attending. But there could be commissioners as a panel. I mean, it could go either way.
And this is an open and noticed meeting of this whatever.
It would be an advertised event where we would be probably doing something through Zoom and of course in online, but it wouldn't be a commission meeting per se. It'd be
who's organizing? Who's organizing?
The commission is organizing it.
Okay.
Yeah, but it is for people to obtain a better understanding of an issue. And commissioners would be there to support the commission in an event that the commission organized. Probably not as speakers, but as listeners.
Right. Well, I mean, the prohibition really extends to commissioners discussing matters among themselves. So if this is an open meeting of another public body that the commissioners are attending, I'm not sure I see any issues. Ted, what do you think?
Well, because it's being called by the commission, and you're going to have a majority of commissioners in attendance, I would think the safe thing would be to go ahead and treat it as a Bagley Keene meeting. If it were being organized by somebody else and commissioners are only going to come and listen, or even they could even theoretically speak at part of the open meeting, then that would be okay. What they couldn't do is bunch up in the back of the room and talk amongst themselves. So one of the exceptions is if you have a publicly noticed meeting. In other words, it may not be noticed under the Bagley-Keene Act, but it's been advertised and noticed as open to the public. And then members of a particular commission attend. That's part of the exception, so long as they don't meet amongst themselves. But the problem here is this is a meeting that's being called by the commission, at which members of the commission are going to attend. And I would think that would, certainly the safe thing to do would be to go ahead and notice as a Bagley-Keene meeting.
Right, and because in particular, I guess the public would have to have enough information to make a decision as to whether they want to attend the meeting. So I second that there should be notice provided.
Thank you, gentlemen. That's really helpful.
Yeah. Well, speaking of which, we're now going to discuss a little bit about the notice requirements, unless there are any further questions.
Yeah, this is Commissioner Lillibridge. I have one question about getting clarity on what's considered commission business. Say, for instance, 3 or more commissioners are in a social setting or having lunch or what have you. Is commission business defined as a particular agenda item on a past or future meeting, or talking about any type of disability access issue, is that off limit?
I think if the discussion takes place in the context of, oh, sorry, go ahead.
No, go ahead. I was thinking you were going to talk, and then when you didn't, I started up. We got this whole delay thing going on.
I think we do have a little bit of a delay.
Yeah.
Well, I was just going to say that if the discussion about disability access is a substantive matter under the jurisdiction of the commission, so if you're talking about it abstractly, or if you're talking about a personal matter, or something that you read in the paper, or something that you saw, that's one thing. But if it's a substantive matter that would be before the commission, that would be appropriate for the commission to be deliberating and making conclusions about, that's I think where I would draw the line. But Ted may have a better way of framing that.
I usually tell people, clearly, if it's on an agenda, or if you know it's going to be on an agenda, then that would be an item that would be under its jurisdiction. When we get beyond that, I think the question is this something that you think is likely or quite possibly going to be a matter of consideration at some point in the future? And if so, then I think you should view that as a matter under the jurisdiction. But if it's unlikely that that's ever going to be something that comes before the commission, then I think you're fine on that. And I know that's not a clear, it's not a bright line. It's fudgy as you approach the line. But I think that's one way of looking at it, to try to figure out whether this is in or out.
Okay, thank you.
Any other questions?
Yes, this is Director German. I wanted to address the idea of close to maybe number 5 of social gatherings in the terms of retreats. This has been something that we've still had honestly publicly developed, but it has been questioned, did we really need to make it a public meeting when we try to create a board strengthening training kind of scenario, and the term of retreat was used as the reference of this type of gathering? How would you address that in this discussion?
Well, let me jump in here.
Sure. Yeah.
I think we've generally said that different kinds of training and trying to think of the word that you just used, but at any rate, working on board relationships and things like that, those are generally things that are being done by the board in its official capacity. They're being paid for. by the board and they're being done in connection with board business. And therefore, our advice has generally been that these are subject to it. And does that make it difficult to do them? Yes. But that's been the conclusion of the government law section at the times that it has been asked. So retreats are, I think, in that sense, are generally frowned on because, again, this is one of the main places where it interferes with people's patterns of communication, because what they'd like to do is get off together and bond and exchange views and get to know each other and where they're coming from and what their philosophies are and that kind of thing. But if the government's paying for it and it's being done for purposes of the board, and inevitably business is going to get covered in these things. And so all of those are the things that cause it to be problematic. So sorry about that.
Any follow-up questions? If not, I think we'll discuss just a little bit about the notice requirements. The details for preparing the notice are generally more a matter for staff, so we're not going to go through all of the details of those rules, but just a reminder that the meeting notice does need to be posted 10 calendar days in advance of a meeting of the commission, and only those items that are listed on the agenda may be discussed at the meeting. Even if the commission is not going to take action on an additional item, it does have to have its own agenda entry. And even if an item is reasonably related to something on the agenda, it also must have its own agenda listing in order to be discussed. Once the 10-day notice has been posted, there are a couple of exceptions that allow the commission to add an item to the agenda. And the first exception is if it would qualify for an emergency meeting, which we touched on earlier. So if a majority of the commission can make a finding that there is a true disaster or a work stoppage or something that severely impairs public health and safety. So it's a very narrow exception, but the commission would be able to obviously discuss that item as if it were an emergency meeting. And then the second exception is if the commission determines that there is a need to take immediate action on an item. And if the commission was not aware of the need to take immediate action prior to posting the notice, and that's really the key. If the commission was aware of facts and circumstances suggesting that immediate action needed to be taken and then posted the 10-day notice, then this exception would not be available. And then procedurally, under the second exception, just as with the special meeting, a revised agenda needs to be posted 48 hours in advance of the meeting and also provided to national press and media. So we just had some quick remarks on the notice requirement. Any questions about that?
The other thing is we did send along to staff a template of an agenda with some instructional comments on it that may be useful to you in the way you frame your agendas.
Okay, so now let's discuss teleconference meetings. As you are well aware, this is an area of Bagley-Keene that has been in a state of flux during the pandemic. First, we'll just discuss the general rules under Bagley-Keene, and then we'll discuss the amended rules under AB 361. So the way to think about the general rules is to really focus on the physical meeting location of the members of the commission. So if the commissioners are meeting all in the same physical location, even if staff or guest speakers or members of the public are joining by teleconference or video conference, that is not a teleconference for purposes of Bagley-Keene. A teleconference is where the commissioners themselves are meeting from remote locations. And so Bagley Keene requires that the notice for the meeting includes the location of each of those teleconference locations where the members will be located. And the agenda needs to be posted at each location. The meeting must be fully audible to the public at each location. The public must have access at each location, as well as the ability to participate in the meeting. And finally, each of those locations must be ADA compliant. So if a member wishes to join a meeting from a personal residence or from the hospital or from an airport, those may not be appropriate meeting locations unless they are in fact fully ADA compliant. And then finally, under the general rules, all voting must be by roll call vote so that the public at different meeting locations can keep track of the results of the voting. So those are the general rules. We'll talk about AB 361 now, which went into effect on September 16th and is effective through the end of January of next year. So we have just over 3 months left. And AB 361 codifies a lot of the changes that the prior executive orders of the governor made that have since expired. And the essence of AB 361 is that there is no requirement for a physical meeting location. This is the teleconference system that we're now all used to since the pandemic began. The requirements are that the notice for the meeting must include the means and procedure for the public to attend and comment. And also any requests for accommodation must be resolved swiftly and in favor of greater access. So if the commission is using a meeting system and getting feedback from the public that for whatever reason accommodations are not working, then the commission will need possibly to explore alternative methods of meeting, perhaps a different video conference system or a teleconference method. And then finally, AB 361 has not suspended the requirements for roll call voting. So roll call voting is still required for teleconferences. So, I should also mention there's an additional set of rules. We thought maybe 2 sets of rules would be enough for the discussion today. Maybe it's just 3 sets of rules might be more than I can handle. But once AB 361 expires at the end of January, there is an exception for advisory bodies to have teleconference meetings under a different set of rules. And we're actually, after this meeting, we're going to circulate a handout that has a lot of the information that we've covered today, as well as some additional information that we think would be helpful. And we've included those alternative meeting rules for advisory bodies. So any questions about teleconference meetings?
So I think the thing that I would emphasize here is that we don't understand why AB 361 has such a short shelf life to it, because it's going to end at the end of January, which is going to be before there can be any new legislation, most likely. So we're going to be returning to the old rules almost for sure, starting February 1. And so in your case, for example, you can still have the same kind of meeting that you're having now. It's just that each location where there's a member present is going to have to be noticed, and is going to have to be fully accessible to the public. And so people who are meeting from their homes, they're not going to want to publicly notice their addresses and invite the public into their homes, not to mention the fact that most people's homes are not ADA compliant. And so that means that either you're going to have to start meeting in the old way, face to face in a room, or if you're going to meet remotely, you're going to want to do that from some kind of public facility, such as a library or a conference facility or a government office, where you can fulfill the notice and accessibility requirements.
Well, thank you, Ted. I think the next section is for you.
Okay. So I'm going to talk a little bit about public rights when members of the public attend meetings. The Bagley-Keene says that you do not have to give your identity to attend a meeting and that you cannot be required to sign a sign-up sheet or anything like that. Now, we have a bit of a twist on that because after 9/11, security needs to do its thing before they let people into public facilities. So our interpretation is to set up a bifurcated system. Security gets to do what security needs to do, and that's going to be checking people's driver's licenses and taking names and all that kind of stuff. But when you get to the meeting, you still have the right to attend that meeting anonymously if you want. So security personnel are not supposed to share the information that they have about people with the people who are running the meeting, because it's explicit that people should be able to attend meetings without giving up their identity. Our further interpretation is that if people can attend a meeting anonymously, there's no reason to require them to give their name if they want to testify. There may be legitimate reasons of privacy or intimidation for why people don't want to give their names, but their viewpoints may still be valid, and you as members can assess what you're hearing and the context in which you're hearing it when you weigh it to determine. And if people want to give their names, that's fine, but our view would be that if they don't want to give their name, that's fine too. And so you should not routinely require that. There are questions sometimes about, can a meeting be recorded or broadcast? We've gotten over a lot of that with the Zoom age. But the answer is that unless the recording or the live streaming of a meeting creates a persistent disruption of the meeting, that it's okay. So if there's some clattering around while people are setting up their equipment for 5 minutes or so, that's not enough to say, hey, you can't do that, get out of here. It would have to be what we consider to be a persistent disruption of the meeting as a whole. People have the right to testify before or during each item. The best practice, I think, for that is that people get to testify in connection with each agenda item after there's been information provided, and probably before the members of the body start to deliberate on it. So again, they get the staff perspective, they get interested members, and they get the public perspective before they start to discuss and deliberate on things. The Bagley-Keene also allows you to hear from any member of the public on items that are not on the agenda. So you've got several items posted on your agenda, but somebody wants to stand up and talk about a disability issue that's not on your agenda. That's perfectly fine. Now, that's a discretionary thing. You don't have to do that. We suggest you do, but you don't have to. Under the Brown Act, which is the local open meeting law, they have to. It says there shall be an item on every agenda for public testimony that's not on the agenda. So it's like an open mic provision that has to be on every Brown Act agenda. And I think that's the best practice for state agencies as well, but it isn't required. Time minimums is another issue that comes up. Can we limit public testimony? And the answer is yes, but it should be reasonable under the circumstances. And again, we would emphasize that you want your testimony process should be designed in order to allow you to hear from members of the public and what they're thinking. They're an integral part of what's supposed to happen with a consensus building body. So you can limit it because obviously you have to be able to have control over your meetings. And we would advise that you have some flexibility in how you do that. We see a lot of bodies that set up with a 2-minute requirement and they cut people off in mid-sentence when the 2 minutes is up. I think I would advise that more flexibility and respect for the person who's testifying should be given in that. But on the other hand, you can't let people go on for 10 or 15 minutes when they're repeating themselves and repeating everybody else. So you look at your meeting and the time that you've got to conduct your meeting and the number of agenda items you have and the number of people who are there to testify. And then you try to mold your limitations in a reasonable fashion to allow you to get through your business and also hopefully for you to be able to hear from interested members of the public. People have access to records. So anytime that a majority of the body receives records, the public is also entitled to those records upon asking in a prompt fashion, unless it's related to a closed session exemption or unless it's privileged legal advice. Records that are brought to a meeting, those that are being considered at a meeting should be brought to the meeting for members of the public. And if you get records from third parties in the course of a meeting, those should be made available as soon as practicable. So that's generally the scope of public rights in attending Bagley-Keene meetings. Anything anybody wants to talk about?
This is Commission Chair Downey. I just wanted clarification on the sort of order procedures for discussion, questions, comments. As I understood it, as you presented it, let's say as you gentlemen made your presentation, make your presentation, then it's open to the public for comment. And then after that, it's to the commission members that might wish to respond. Is that the proper order as you see it?
I think that's the generally preferred order. You get a staff presentation that tees everything up and gives you certain kinds of information. Then you get public viewpoints who are saying either we agree with that or staff forgot to tell you, or here's something else that you might want to consider. And then you're armed at that point with both the staff's information and with public comment, and you're ready to have a full-fledged discussion about what to do. So ordinarily, I think that would be the preferred way of doing it. There may be some situations where adjusting that model a little bit makes more sense.
Thank you. And this is Commissioner Downey again. There's one other item I wanted to confirm and seek some guidance when it comes to taking a vote. In the interest of time, if we were to have a vote by yays and nays, if it's clearly unanimous, do you then need to do a roll call vote, or should you just always default straight to a roll call vote?
Well, it partly depends on the type of meeting that you're having and the rules under which you're having it. So as Thomas was saying, I think it specifically specifies roll call on teleconference meetings, doesn't it, Thomas?
That's correct.
Yeah, it uses that word.
Okay.
But in any meeting, you are now required to record the individual vote of each member. And so even if you're not doing a roll call, you need to be able to record that Smith voted nay and Johnson voted yay. So the idea of a voice vote, and you hear, five people say yes and one person say no, and you say, well, the ayes have it, and you move on. You can't do that anymore. You have to be able to record the individual votes of each member.
This is Commissioner Paravani. I had a quick question on public comment. To my knowledge, this board has never done it, but I have been a part of and seen boards during the public comment session tell the public that if you agree with the comments that have previously been offered, you may come to the mic and say, I agree with, Speaker John Smith, and not repeat those points. Is that valid?
Well, that's certainly not a good way to do it in my viewpoint. And if you do that, that doesn't mean that you still don't have to allow everybody from the public who wants to testify in agreement or disagreement to be able to come forward. So I've never seen that before, and that seems strange to me. Now, we've had situations where you have a meeting, for example, and you have 75 people show up. And if you give each of those people this customary 2-minute concept, you will be there for 2.5 hours listening to mostly duplicative testimony. And that's not healthy for you, and it's not healthy for the public. And so I've seen situations where chairs have then tried to figure out a way to kind of manage the situation. So some things that are you can do are to say, do we have people here from particular groups, and can we get a spokesperson up here to talk for 15 or 20 minutes and represent 50 of you folks, for example? Or you might begin the testimony saying, we've got these 2 issues, and as part of the public testimony, can I get a show of hands of how many people are inclined towards this concept and how many are inclined towards that? That's another way of people being able to give input. And then you see that the audience is voting 3-1 a particular way. And so then you can figure out how to do that. You can see if people could send certain representatives up, and then when you're finished, you can say, did we cover everything? Is there something that somebody feels like they need to add that hasn't been covered? So there are ways you can kind of try to manage a situation to handle a big or difficult logistical situation. But the situation that you suggested seems somehow designed to limit or restrict or suppress testimony in a way that's, I think, not intended.
Okay, thank you.
Okay. Thomas, are you up? I think I finished.
Yes, so now we'll discuss a little bit about closed session exceptions. So the general rule under Bagley-Keene is that meetings of the commission must be open to the public, but there are a number of exceptions in the statute for closed sessions on a number of different topics. These are narrowly construed by the courts. We will only discuss the 2 most common, which would be the personnel exception and the pending litigation exception. So let's start with the personnel exception. This allows the commission to meet in closed session to discuss hiring, firing, evaluation, and discipline of an employee of the commission, or to hold a hearing on any charge or complaint against an employee. And the purpose of the exception is to avoid potential public embarrassment of the employee if the commission has to have a frank discussion about the employee. And procedurally, if the commission is meeting to hold a hearing on a charge or complaint or a possible dismissal, the commission has to give the employee 24 hours advance notice and also inform the employee of the right to hold the hearing in open session. So even though the purpose of the exception is to avoid potential public embarrassment of the employee, it's actually the commission's call whether to hold the hearing in a closed session. If the commission decides to hold it in closed session, then the employee has a right to be heard in open session. If the employee elects to hold the hearing in open session, the commission may still deliberate in closed session. And in fact, at that point, the employee does not have a right to attend those deliberations. And then upon concluding the closed session, the commission is required to report on any action taken, as well as the results of any roll call vote to appoint, employ, or dismiss an employee at a subsequent meeting. So that reporting out is not required to occur in the same meeting. That can occur in a subsequent one. So now we'll move on to the pending litigation exception. This allows the commission to meet in closed session with legal counsel to discuss litigation strategy or potential terms of settlement regarding pending litigation. And the purpose is so that the commission will not prejudice its position in the litigation by spilling the beans in an open meeting about a potential strategy or settlement terms. Under Bagley-Keene, litigation is pending if the commission is a named party in a case filed in court or in an administrative hearing, if the commission is considering initiating litigation, or if because of existing facts and circumstances, the commission has substantial exposure to litigation. And the substantial exposure test is a little intricate. We'd be happy to provide some more information, perhaps after the meeting. So now just some general notes about closed sessions. Each closed session needs to be included on the agenda, as well as a citation to the statute that allows for that item to be discussed in closed session. So you have to cite to the exact Bagley-Keene provision that allows for that closed session exception. If the commission is meeting to discuss pending litigation, the case title needs to be included on the agenda. If there is a case title, there may not be one. And then the commission must convene an open meeting and then announce that it is going into closed session. And then at that point, the public actually has a right to comment on the closed session agenda item. So the public does not have a right to attend the closed session, but it does have a right to comment on the agenda item. And so it is appropriate to pause for public comment before going into closed session. Once in closed session, the commissioners may only discuss the particular agenda item, the item that is listed on the agenda. As we mentioned earlier, even if a topic would be reasonably related to that item, if it does not have its own listing on the agenda, then the commissioners may not discuss it in closed session. The commission should appoint a member of staff to keep confidential minutes of the closed session, keeping minutes of any items discussed and any decisions taken. And we advise the commissioners that only essential persons should be present in the closed session because of the strictly confidential nature of the information exchanged in closed session. So for example, if you're meeting to discuss pending litigation, then you would have staff to keep the minutes. And of course, legal counsel would be required if you're meeting to discuss pending litigation, and then any other persons who would be essential to that discussion. And then one final note about closed sessions, the commission cannot adjourn the meeting out of closed session. So the commission will have to reconvene in public session before adjourning. So any questions about closed sessions? If not, I think the final portion of our prepared remarks is on remedies for violations of Bagley-Keene. So there is a potential criminal penalty for violating Bagley-Keene if a commissioner intentionally deprives the public of information that the commissioner knows or had reason to know the public has a right to know. So an intentional violation of Bagley-Keene can be punished by a misdemeanor penalty, which would be less than a year in jail or perhaps some sort of monetary fine. I'm not actually aware of anyone who's been prosecuted under Bagley-Keene, but it is something that the commissioners should be aware of. I'm sorry, is there a question or?
Yeah. I'd like to ask if members of the public or commissioners, if you're not speaking at this time, please mute your microphone.
Commissioner, this is Adam Barsanti. There was just a little bit of feedback on our end. Apologies.
So as I was saying, we're not aware of anyone who's been prosecuted under Bagley-Keene, so it's difficult to say what the range of penalties would actually be. And then the civil remedy would be to bring a case, an interested person would bring a case in court to have the court grant either an injunction against a future violation of Bagley-Keene or to void any action taken in violation of Bagley-Keene. And then if the plaintiff prevails, the plaintiff also has a right to have attorney fees paid by the commission. So an injunction against a future violation, voiding any action taken in violation of Bagley-Keene, and then the commission would likely be on the hook to pay attorney fees of the plaintiff. And now in a civil action, there is a defense for substantial compliance with Bagley-Keene. So if the commission has substantially complied with the notice and open meeting requirements of Bagley-Keene, and there's really just a foot fault, then the plaintiff will likely not prevail in an action against the commission. And Bagley-Keene also does allow the commission to attempt to cure or correct any violation of Bagley-Keene. And so the way to think of this is conceptually to sort of go back in time before the violation occurred and then reintroduce the item in full compliance with Bagley-Keene. And so if possible, that will likely remedy many different kinds of violations of the act. And Bagley-Keene does allow the commission to cure or correct a violation. So any questions about remedies? I think that takes us to the end of our prepared training. So I think, Ted, we should just open the floor for any general questions about Bagley-Keene.
Correct. Absolutely. Anything you want to talk about that we've covered here or didn't cover, now would be the time.
I have a question. This is Ida Claire. So I'm a little confused on the requirements of saying if you echo and provide the same comment as someone else, you're welcome to say, I agree with so-and-so and that is my comment. But yet you're saying you can collectively get them to have a representative to state the comment. I don't see how one is more limiting than the other.
Well, perhaps I misunderstood, but I thought what the person was saying is, if you agree and only if you agree, you can come up and testify. And what I was saying was that can't be the extent of it. I suppose you could do that. But at some point, the people who don't agree have to have their full right to comment as well. So I just wasn't sure.
This is Commissioner Paravani. I think I may have misstated my question. I was trying to explore the scenario where person A takes a stand and person B agrees with that stand and comes up and says, I agree with person A, but that doesn't mean that person C, who disagrees with A and B, couldn't come up and express themselves.
Correct.
Yeah.
So sorry if I misunderstood the question.
Perhaps I wasn't clear. I'm sorry.
Ms. Claire, does that clarify your situation?
It does. Thank you.
Okay.
Well, as we mentioned earlier, we will be circulating a handout with a lot of our remarks as a good refresher. And of course, that may lead to additional questions. We're always happy to discuss Bagley-Keene. Are there any other general questions?
Okay, so it sounds like we've completed the training, and again, if you have follow-up questions, get in contact with one of us and we'll try to help you out.
Thank you very much. This was very helpful.
Yeah, thank you,
And
Ted.
other than that, good luck, and particularly good luck, figuring out how to move forward as the requirements for conducting meetings change.
Okay, thank you very much. It's very helpful training. So thank you. Clearly, we've run over our morning scheduled time. It's now a little after 12:30. Staff, do we have concerns about the afternoon agenda when outside speakers might be on the hook for being present for their presentation?
Commissioner Downey, this is Adam Barsanti. We are actually reaching out to our afternoon speakers at this time, and we will keep you notified of any changes that may take place, but we are working on that as we speak.
Is that to say that at this time, if we were to adjourn for lunch, that we should plan on being back on at 1 o'clock? Or how will we get word out to the commission and to the public?
Actually, we're working on that as well, sir. I apologize. I'll have to speak with Executive Director Jamot. We're also currently experiencing a little bit of technical difficulty as well on our end, but we'll work through that and we'll keep you notified just as soon as everything comes through.
Okay, well then I think I'll take the privilege of saying that unless we hear otherwise, we'll reconvene at 1 o'clock. But if you do get word out to us, that would be greatly appreciated. But
okay.
Until then, I think it's 1 o'clock start time after lunch.
Actually, Commissioner, I do apologize. Actually, I was just notified by our operations manager that we'd like to move it to the 1:30 time, so still maintain it as an entire hour.
Okay.
Allows us to adjust accordingly.
All right. So then we'll adjourn for lunch for an hour. Nominally an hour. It's 12:33, so we'll reconvene at 1:30. Thank you, everybody.
Thank you
for lunch. Okay. Thank you, Adam. So I'd like to call the afternoon meeting of the California Commission on Disability Access back to order. My name is Chris Downey. I'm the Commission Chair. And so at this point, I'll return to agenda item number 10, which is the sort of the historical and review up to current times of Title III. And for that, we have Andy Mudrick, the Chief Deputy Director of the California Commission, the California Department of Rehabilitation. So as I asked, since Angela is not yet with us, if you could introduce yourself, we would greatly appreciate it.
Yeah, I'm happy to do that. Thank you so much for having me. And it's a pleasure to join you all and to give you my perspectives on the history of ADA Title III and how we got to where we are today. I am the Chief Deputy Director at the California Department of Rehabilitation, or DOR. We serve people throughout the state with disabilities who are seeking employment or seeking to advance in or retain employment, as well as serving individuals with disabilities who are seeking independent living. So we fund in part the 28 independent living centers throughout the state. By way of personal background, I was born with a disability called osteogenesis imperfecta, or brittle bone disorder. I sometimes use a wheelchair, scooter, and sometimes walk. And so this work is very near and dear to my heart. I'm an attorney by training. Governor Newsom appointed me in this role in July of 2020. Before that, I was the chief counsel here at the department. And before that, I worked for many years advocating for disability civil rights. So I was the deputy director at Disability Rights California, overseeing all of the legal work there for 11 years. And have been an attorney for 32 years, in large part advocating for people with disabilities in a wide range of cases. Wanted to talk to you all about the importance of this commission, the importance of ADA Title III, kind of in the context of the civil rights movement, and where people with disabilities were historically throughout the United States, and particularly here in California. And so I'm going to give you a little bit of history and background, and wanted to start by saying that for me, I know many of you here have disabilities or know and love people with disabilities, and for us, community living is a civil right, and that we don't take for granted, and it's not something that we have always had historically. And as part of community living, it's to have, the right is to have access to full range of services, benefits, opportunities, recreation, employment, housing, transportation that people without disabilities have. In California, it wasn't until 1968 that the state legislature recognized the right of people with disabilities to have equal access to public facilities under our UNRU Act. So that's our state statute. And as late as that seems to many of us, wasn't until, as you know, 1990, that our federal law, the Americans with Disabilities Act, was passed and contained Title III, which is the statute that requires places of public accommodation to provide equal access to people with disabilities, to provide modifications of policies and procedures to allow people with disabilities to fully benefit and access places of public accommodation, also to receive effective communication services. And then it wasn't until 1999 that the Supreme Court, in interpreting ADA Title III, held that the unjustified segregation of people with disabilities in living situations is a form of unlawful discrimination of the Americans with Disabilities Act. So as I'm sure you all know, the ADA contains an integration mandate requiring that people with disabilities have the right to participate in the least segregated settings. And for folks, and in this case involving institutionalization, the court held that, again, unjustified institutionalization of people with disabilities was a form of unlawful discrimination under the ADA. These statutes come after centuries of dehumanization, oppression, and segregation of people with all types of disabilities throughout the country and in California. From the mid 1800s to the 1960s, people with psychiatric disabilities lived in state institutions in psychiatric hospitals, and thousands continue to do so today. One of the sad pieces of that history is that about 45,000 people during that time died while living in state facilities, and the state did not consider them human enough to be buried in marked graves. They were actually buried in mass graves, and there are incomplete records about those individuals. The California legislature in 2002 recognized that atrocity and established California Memorial Project and Remembrance Day, which is held on the third Monday in September. And that event is meant to honor those individuals who died living in institutions and were buried in mass graves with incomplete records. Another instance of segregation and oppression of people with disabilities in California was in 1853, the creation of the developmental centers. So developmental centers throughout the state were created to house people with intellectual and developmental disabilities. So those folks, as people with mental health disabilities, were not allowed to live in the community. There was significant shame, incredibly low expectations of their value to society, and about 13,400 residents used to live in developmental centers in California. And it wasn't until 1996 that the state started the process of closing those developmental centers and integrating people with intellectual and developmental disabilities into community living. Happy to say that all of the state development centers have been closed except one called Porterville in Southern California, which still houses a few residents, and there are plans to close Porterville as well. Not only were people with psychiatric disabilities and intellectual and developmental disabilities placed in institutional segregated settings, but people with physical disabilities and traumatic brain injuries were as well. Many of those individuals lived in skilled nursing facilities when they could have lived in the community. An example of that is residents who lived at Laguna Honda Hospital in San Francisco, which was the largest nursing facility in the nation. Proud to say when I was at Disability Rights California, my colleagues brought suit to challenge the segregation of those individuals. And as a result of that litigation, individuals with physical disabilities, traumatic brain injuries, who could live in the community with appropriate supports and services were allowed to transition to community living. Even after integration of folks with disabilities in recent years, there continue to be cases where folks with disabilities are segregated. We have, for example, even in the community, we have some restrictive zoning ordinances prohibiting or restricting the rights of people with intellectual and developmental disabilities, people with mental health disabilities, people with substance use disorders, living in group homes in communities. And there have been legal challenges to those restrictive zoning ordinances. We also tend to house people with disabilities disproportionately, so people with mental health disabilities in jails and prisons. So you might be surprised to learn that Los Angeles County Jail is actually the largest provider of mental health services in the country. And as a part of that, folks who have been incarcerated, folks who have mental health disabilities, 70% of homeless people have been incarcerated, the majority of whom have some sort of disability. So with that said, we've made a lot of strides, right, and especially over the past several decades. We, as you know, we have the Americans with Disabilities Act, Title III. We have our UNRU Act, which create, as I said, that recognize the rights of people with disabilities to access places of public accommodation. And this commission has an incredibly important role to play in that respect. And so I am really happy to talk to all of you today. As you know, the legislature has recognized that people with disabilities have their right to full and equal access to public facilities, and that a violation of the ADA also constitutes a violation of state law, the UNRU Act. And the legislature recognizes that people with disabilities continue to be denied full and equal access to public facilities in many instances. And as a result of that recognition, the legislature created the California Commission on Disability Access to help develop recommendations to enable people with disabilities to exercise their full and equal access to public facilities. And the legislature intended that the commission be broadly representative of ethnic, gender, and racial diversity of the population that it serves, as well as broad disability disability diversity, recognizing the segregation, the oppression that people with all types of disabilities have faced in California as part of our history. So anyway, that's my brief history in a nutshell. And I just really thank you for allowing me to come and talk to you this afternoon about that history. And I'm happy to open it up to questions, conversation, if there's time for that.
Thank you, Andy. Is Teresa there? And are there members of the public that would like to raise any questions or comments?
Chair Commissioner Downey, at this time, I don't see any hands raised or any mention in the chat of individuals from the public that would like to speak to you.
All right, thank you. So I'll open it to any commission members.
Hi, this is Commissioner Paravaglia. One of the things that is a concern that comes to mind as you were speaking about people living in segregated environment is the aging of California and the notion that many people as they age, because of residential building standards, can't live independently in their own home and require certain kinds of assistance, which sort of sets the stage for them living in a segregated environment, in some cases, perhaps prematurely. Do you know of any work that's being done on that front?
Yeah, I mean, and great point, Commissioner. So yes, seniors are probably the largest growing demographic in the country, right? We have a California Department of Aging. We have a department that's focused on these issues. There's, as you indicated, significant crossover between access that folks with disabilities face and that seniors face, and so kind of significant crossover in the barriers that both populations face. There was recently developed after significant work, a master plan on aging. I believe you can find that document on the California Department of Aging's website that talks about a number of recommendations to be made to allow for community integration, community living, including significant modifications to our provision of long-term services and supports for both seniors and people with disabilities. And so there continues to be quite a bit of work in that regard. The governor recently appointed a special advisor on disability, aging, disability, and Alzheimer's Kim Johnson is, not Kim Johnson, Kim McCoy Wade is the new advisor, and Ms. Wade was the director of the Department of Aging until a few weeks ago. And so there are significant efforts to look at these issues. They're, as you know, they're complicated. Many involve various funding streams, and that requires significant thought and braiding and blending of funding to address. But yes, the good news is there are efforts, and I think more to come.
Thank you. That's helpful. I just was kind of wondering what was happening on that front.
Are there any other questions or comments from the commission? Hearing none, I'd like to thank Annie Buttrick. Thank you so much for coming and sharing that information with us. We greatly appreciate it.
My pleasure. And I put my email address in the chat if anyone wants to follow up.
Perfect. Thank you. So next is agenda item number 11, our review of our 2021 strategic goal. And I heard that Executive Director Jamad is back, so I'll turn it over to you.
Thank you so much. We have been in an interesting journey in these last 2 years. And I'm proud to say that in spite of some levels of setback, we have done tremendous work. And so especially just to say that with the strategic goals that we plan, they are on track to be completed 100% at the end of the year. And so that is a lot to be proud of, in spite of the fact that we had a number of setbacks. And so with that, I would like to have Teresa Brown actually give some more detailed highlights of the completion of strategic goal and the evaluation of attorney compliance with the California Commission on Disability Access data collection mandate by researching Title III, construction-related American with Disability Act, court filings and submission practices within the California federal district and state superior court systems. So with that said, Teresa, if you can lead us in discussion of that particular goal.
Yes, thank you. So just to remind you of the critical paths that we have currently completed, the first path was to basically develop a research outline, and that included the criteria for our data review. What we were going to look at were 62 court systems, 4 federal district courts, and 58 state superior courts in California to determine the attorney submission compliance with the 5-day notification requirement to the CCDA for their 2020 ADA Title III construction-related filings. Our second path was to actually collect that data. We were collecting the data from our database a legal database that we were working with, LexisNexis, and we were also looking at our court records from our ServiceNow portal. And then as we went into our third path, it was based off of analyzing the data, the 2020 ADA Title III legal complaint data. And our critical path 4 was to create a draft letter to California licensed attorneys that would be included in the California State Bar newsletter. And we have just completed step 3 and 4. And so as of September 30th, our data has shown that out of approximately 6,757 US California Federal District court dockets, as well as 145 California State Superior docket records located in the LexisNexis legal database. We have located 13 attorneys or law firms that were not registered in our ServiceNow portal. And so that added up to basically approximately 2,079 records from 2020 that we were missing from our ServiceNow portal. In 2020, we had an estimated 3,063 documented case filings. So that actually is compelling data so far that we have been able to identify. And we're on our path to finish the fifth step. That will be due on December 31st of 2020, which is to provide recommendations on how to reach out to the unregistered law firms who are filing these ADA Title III cases and introduce them basically to the Civil Code 55.32 mandate, as well as to assist them in becoming familiar with the ServiceNow portal to help increase the compliance of the statute and submissions of their cases to the CCDA. Angela, did you have any additional comments that you would like to?
So I did just want to add, thank you, Teresa, for sharing those numbers. I just wanted to say how we had seen just for a slight marketing opportunity that we provided to a number of the attorneys and law firms that we were able to reach out to. Now we had seen a major increase in our portal just by our we sent out 2 different letters as of today. And with that said, it changed dramatically just the submission of our portal. So as of July, and this is some numbers just to give you a sampling, that in July 1st, we had 3,030 submitted cases compared to last year, which was 3,063. So just up into, for a whole year, we doubled just by that communication, our portal. So it has definitely paid off and it's progressing just right now. So you can understand probably when we get to the discussion on our strategic plan for next year, that we know that marketing and communication is important. And so we've been working very diligently of making sure our portal is correctly capturing the information. And we'll talk a little bit more about that in our strategic goal for 22-23. But it indeed, we have a great accomplishment, so we can say that we made it through into 2021's strategic goal. So with that said, we could move into the highlights of 2021, if you like, Commissioner Downey, if there's no questions or comments.
Let's see, are there any questions or comments from members of the public on this item? And hearing none, any comments from members of the commission? Hearing none, let's move on to the highlights.
So Teresa, why don't you go back in and talk about some of the highlights, please?
Yes, thank you. So our historical data input project has also progressed, as Angela had mentioned. And it's been reported, basically, our major accomplishments include retaining a dedicated consultant for our ServiceNow portal. We've completely eliminated the CCDA external database that we were using to manually enter in the ADA Title III case submissions. We have also completed our 2020 historical data entry into the ServiceNow portal, and we have just begun our process of data migration for the remainder of 2019 historical data, in addition to troubleshooting our transition of the 2012 through the 2018 cases through data migration. So some very positive accomplishments to report. Angela, if should I'd like to defer back to you before we go into Roman numeral 2 of the extended, the outreach of the open dining and curbside pickup, if there were additional comments that you would like
Yes.
to.
No, I like to make drama, I guess. I mean, what Teresa said is a huge transition for CCDA. We have been manually inputting this data since the beginning, 2013, and we've eliminated that process totally. And so it is no longer any documents going into a manual system. It has all been rectified of manually inserting. And so now everything goes into the portal. And so we'll talk a little bit more deeply about what's next, but that is a huge step. There's been a lot of challenges with that. So that was one of the highlights. And I would like Adam to join us to discuss a little bit more about some of the highlights of 2021.
Yes, good afternoon, everybody. So yes, I'll be covering items 2 and 3 for the 2021 highlights. So number 2 would be the extended marketing and outreach of open air and curbside pickup disability access considerations. We actually redistributed our open air document to additional stakeholders and organizations in order to maintain and encourage accessibility compliance. And some of this was mentioned earlier in Director Jamat's executive review. And also she had mentioned that CCDA will be partnering with the Division of the State Architect and the California Office of Small Business Advocate to hold a series of webinars on accessibility. The first presentation will be tomorrow, the 28th. And again, this was mentioned. I also wanted to make a special announcement that that information actually is located on our website. And the meeting is via Teams, and you can find that information on our events tab. So utilizing our website to hopefully join us to that meeting would be greatly appreciated. And then moving on to item number 3, we actually, I guess, relaunched or launched our accessible parking campaign to go kind of in conjunction with our open air toolkit that we have. And this actually is to echo what Commissioner Holloway had mentioned in his subcommittee report, that the CCDA sent out a survey to determine the method and content stakeholders would want to receive the upcoming toolkit. The 3 professional groups that received the survey were business owners and property managers and owners, ADA coordinators and local governments, and construction and contracting specialists. Each group, actually, we had a very successful survey turnout of the many messages that we sent out. Our business group received over 200 responses, which is a wonderful turnout. And our ADA coordinators and local governments we received 53 responses, which again is very encouraging. And our construction and contracting specialist group received 66 responses back. And through all 3 groups, the results actually were very similar. Overall, the groups wanted a toolkit in a digital format with written requirements that also have photographic examples of those requirements to make sure that they're within compliance. And they also want a toolkit that provides extensive detail on all applicable requirements that are in a language that is easy to understand and interpret. Again, this is all stuff that Commissioner Holloway had echoed in his subcommittee report, and I'm happy to take any questions. And as Teresa has shown on the screen here, there's a lot of information that was part of this survey. So if anybody has any questions, I'll be happy to try and field those. Ma'am,
Thank you, Adam.
Back to you.
Yes, I wanted to just thank Adam and Teresa. They both have been doing some tremendous work. I wanted to add in a little bit of note just for our public record that we also had our open air. It was published in the California Economic Development Journal in the summer of their publication this 2021. So it definitely, the open air has been a great success and has been marketed well. And we do know that we had so much feedback from it. We knew we needed to do more with it. And we have some strategies of how we're going to do that in our next discussion point of strategic plans for 2022-23. And so with that, if there's no other questions, Commissioner Downey, we could go into our strategic plan.
First, Teresa, are you seeing any members of the public wishing to address this agenda item?
Chair Commissioner Downey, I do not see any members of the public indicating that they would like to address this item.
All right. Thank you, Teresa. Any comments from the commission? Okay, thank you. This is Commissioner Chair Downey. I would like to ask for a clarification. When you say that all filings are electronic now, is that to say there is nobody is reporting, there are no reports coming in and on paper? And then second to that, if there are or if they're not, is it an option and nobody is taking us up on that? Or is it everybody is successfully migrated over?
So great question. The system is available if someone doesn't know our portal, but we will not capture it in a manual system. We will automatically capture it and put it into the portal. At one time, we were collecting and putting information into the manual system because we didn't have the vehicle to enter or pre-register on our own. We've eliminated that issue. And so we can pre-register, it's a sense of those who did not register because they have their own access. So we have what we call a pre-registration process internally. And then we would then communicate to that law firm or lawyer that there is a portal, and we will work with them to ensure that they are trained. It is on our website also, just to say there is a manual of how to use the system. And so they have that. We created the tab, and I think from Disability Rights, we had some comments from some attorneys saying, it's a little buried. So we actually created a tab for the legal community. So it's straight to go into our website. And then lastly, Teresa and Stephanie have been working very diligently with any law firm who calls and asks questions. And so we've actually conducted training sessions for anyone who had questions about certain aspects. So I think with those type of support, we've created the reduction dramatically. And so the next stage is those numbers that we've already indicated who are not aware of CCDA and not reporting, and we'll be working on that next.
Thank you. And I'd like to follow up on that too. I was curious with those firms that you've identified that have not been filing, and as you've reached out to them, have you heard responses back to them as to why they haven't? Were they aware of their requirement for doing that? What sort of feedback did you get from that, if any?
So far, it was just unaware. That we have not reached to all of them, but the ones that we've talked to, they weren't aware, or they said they had problems. And so with that, we've eliminated their problems. And so now they're in.
Yeah, thank you. Any other questions or comments from the commission? Hearing none, let's move on to, I believe it's agenda item 12. I'm going by memory at this point.
Yes.
This would be the strategic plan for 21-22.
Yes, again, this is Angela Jamont, and we've probably been hinting already of our goal for the 22-23 year. We have done a tremendous job. Staff has been amazing in working with what we call the outliers. Well, how you put that? Those who had not known about CCDA, and we have also re-established some communications with the state bar, because the reality is the law became in existence in 2013. If you became an attorney in 2015, you didn't know about it because that marketing or communication that came out was then. So there's some good reasons why there are a number of them who weren't even aware. So we have have plans as our strategic goal is to, well, I should say that's part of the closeout, is that we will be marketing to them and then continually to make that part of our process, because it's a newsletter that comes out from the State Bar that shares updates. The newsletter doesn't exist or keep pinging attorney. So we know we have to do some continuous communication. But as we are building this relationship of receiving all those cases, we have to make sure that our system is adequately supporting all records coming in. And this is why our recommendation for 2022 is to complete the historical migration that we have in our portal. So what this means is that there is, as Teresa mentioned, we have a historical section of our portal that needs to be combined into one system. At this juncture, there is a external system that needs to be migrated. And as we mentioned, we just hired a consultant to help that migration. So we are in communications with that team to help us develop a strategy. Some of it is, a lot of it depends on CCDA staff to help map the language to coordinate between the portal and the holding historical data that's outside of the current portal. Right now, the portal holds 2020 and all of 21 and a portion of 2019 up to April. So we want to be public facing to anyone who wants to read or collect data from our system. And so we want all our records in there at minimum 5 years. And so we are working on a strategy with our IT department of how to make that happen. We'll be producing that strategic detail by the end of the week. But the reality, the general sense of the strategic plan is to fully stand the historical record and make one portal, and not a historical section and a current section, but one portal, and then make it public facing. We have been talking about this for a while, of creating reports and available to our public. This is incredibly important to us, that those who have been asking us for manual presentations of public records of attorneys that are in the portal, they will have that access once we finish this process within our strategic goal. So that is our first step in terms of our strategic goal, is to fully make our historical data as one in the portal, and then create reports access to the public that they may be able to pull data down on real time themselves, and not through a request from CCDA staff in time. So you can imagine all the benefits that will come from this completion. The second and the goal for 2022, some reason 2022 is hard to say. 2022 and 23 goal is that we will be developing a full series of the open air tool, open air dining and public curbside pickup. This, as many of you have felt that we were doing something temporary and that the public will go back to normal. A new norm has been created in this pandemic that many businesses have found, wow, I was temporarily creating a space of 50 outdoors. Now I have 50 outdoors and 50 indoors, and I'm gonna keep it that way. Or the curbside pickup, I have a new strategy of getting my goods and services by curbside pickup. And so with that, we know that, and we've been flooded with great comments from what we've developed so far, but we've also been receiving comments of, what about XYZ? You don't have that comment in your consideration. And so what CCDA staff and marketing team and support and subject matter experts will be doing is creating a series of webinars, as was mentioned. The first one is hosted tomorrow at 3 o'clock through GoBiz, and Ida Claire from our state architect will be going through the technical details of that open air with our public. And so we'll do that tomorrow, but we will be creating a strategy for the rest of the year to have people comment and have our local jurisdictions to participate in future seminars to discuss what other areas that needs to be highlighted and added. And at a series of times, we will then update the open air document to have it more robust based on the feedback and the comments that we've had through the series. The series is not scheduled yet, but that is our strategy in general of what we're planning to do for the next fiscal year with this document. So with that, that is our recommendation. And if there's any specifics that you like to see or that I did not mention that you like to comment on, I would welcome them.
Teresa, are there any members of the public that would like to address this item?
Chair Commissioner Downey, I do not see any indication of public interest in commenting on this item.
All right. Are there any commissioners that would like to comment on this item? Hearing none. Okay. If there are no questions, then it's I'd like to hear a motion to approve, a motion to adopt the recommendation.
This is Commissioner Lillibridge. I'll make the motion to accept the recommendation.
Thank you, Commissioner Lillibridge. Can I hear a second?
This is Commissioner Paravani. I'll second it.
Thank you. So, per the training earlier today, it would appear that we need to take a roll vote. So, Teresa, are you prepared to do that?
Chair Commissioner Downey, yes.
Commissioner Downey?
Yes.
One of the things that let's talk about it for just a second, is that he mentioned that we can do yays. If there's a nay, then we need to make sure we identify who was the nay. If there's a unanimous yay, then we can assume we'll give everyone the.
Okay, well, I appreciate that. I prefer to do it that way.
Okay.
So all in favor, please say aye.
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 Aye. Aye.
Aye.
Plenty of time. All those opposed? Hearing none, the vote is unanimous. The motion is passed. And oh, sorry, I didn't ask for any abstentions. Are there any abstentions? Okay, again, the motion is passed. So agenda item number 13, future agenda items. The next commission meeting would be on January 26th of 2022. Any comments from the public on this agenda item?
Chair Commissioner Downey, I do not see an indication of any interest in commenting from the public.
Thank you, Teresa. Any comments from the commission?
Yeah, I have one.
Who's speaking, please?
Okay, I was trying to get it off on mute. It's Commissioner Dillard. I have one, and it's in reference to some of the comments we heard earlier from the public. And if I recall correctly, a lot of the comments were dealing with the school district. And I'm not sure if that's in our domain per se, but I'm just curious, how do we want to respond to that?
Thank you for that point. I've had that question as well, and we've been discussing, looking into it to see. But I think it's being that we've had comments, we should take that up and consider having that as an agenda item to address one way or the other.
Yeah.
Anything else?
No.
Any other commissioners? So with that, then I'll make the motion to adjourn. Could I have a second?
Commissioner Jackson, I second.
Thank you, Ms. Jackson. Commissioner Jackson. All in favor, say aye.
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 All opposed? Hearing none, the motion is passed. We are adjourned. Thank you, everybody.
Thank you.
Excellent meeting.